Serial number 23, Lal Keshwar Prasad versus the Union of India for the petitioner Sri Hemant Kumar Karn.
Maybe you should. That I am supplying the list of. In order is your Lordship order dated 27 January 2017.
Speak in mic, sir.
Passed by Honorable CAT Patna bench, annexure 13. My Lord, the petitioner now retired from service with effect from 31st July 2017. But it was a disciplinary case matter. Major punishment has been imposed upon him, affecting, my Lord, his entire pension and pensionary benefit. Annexure charge memo, your Lordship will find, in, this is dated 16/8/2008, annexure 1, page number 15. My Lord, the 3 articles of charges were there, and my Lord, the allegation is that I did not produce relevant rule before the telecom district manager Motihari. It was a purchase matter, your Lordship, and my Lord, no, my Lord, intention regarding, my Lord, upon my intention on motive was there. Thereafter, my Lord, inquiry proceeded. Article number 1 came to be not proved. Article number 2 partially proved, but my Lord, in a manner invented by the IO. And my Lord, article number 3 proved, but that is very relevant, your Lordship, how the inquiry officer has, my Lord, recorded his.
No, we are not appreciating evidence.
My Lord,
While
my
sitting in
Lord.
Article 226 of the Constitution.
Your Lordship.
Any legal issue is there, you please let us know.
My Lord, this was a common cause. Same proceedings were initiated against 3 persons. And my Lord, 3 different orders have been passed. I have been imposed, my Lord, reduction to a stage for 2 years.
Where is the common proceedings, sir? Where is the joint proceedings?
No, joint, separate charge memos were there.
Therefore, you can't say that it is a joint proceedings. It is an independent.
My Lord, my Lord.
You can't say joint proceedings.
My Lord. My Lord.
Joint proceedings, there is a separate rule, I think, if it is Rule 13, common proceedings.
Your Lordship.
That is not invoked by framing charge.
3 persons
It is an individual inquiry.
Individual inquiry, but my Lord, charges were one and the same. Upon myself.
That's a different aspect. It all depends on each and they should have, you should have taken the contention that it should have been common proceedings in order to overcome overlap of the officers' duties and responsibilities.
Your Lordship.
At the initial stage you should have questioned this.
My Lord, page number 46. I would be praying, my Lord.
Sir, any legal issue, please let us know. What is the penalty?
Your Lordship. Reduction to a stage, your Lordship, for 2 years with cumulative effect. Reduction to a stage, my Lord, for 2 years with cumulative effect.
You have exhausted
punishment
the
order
remedy
is, my Lord, annexure 7, page number 56. The relevant page is, my Lord, page number 59.
All right, sir. You have preferred appeal. Appeal is also rejected. Now, what is the legal issue? Please let us know.
My Lord, there are after, my Lord, 2 persons, myself as well as, my Lord, one Rameshwar.
One point is discrimination.
Discrimination, my Lord.
That is not available to you because it is not a common proceedings.
No, discrimination committed by the Honorable Tribunal. My Lord, myself was imposed punishment. Another
authority has given the reason. One was the general manager. Only initials were there. You were the main person. Being the accounts officer, you were the main person.
Your Lordship, 3 punishments order I have produced before your
Tribunal
Lordship.
Order is very clear.
My punishment order is at page number 59. My Lord,
don't equate with other persons. All individual proceedings.
Sir, other persons you can point out discrimination provided if there is a common proceedings held against 3 persons.
My Lord, my Lord. My Lord.
Any other point, legal point?
Legal point, my Lord. 2 OAs were filed, my lord, before Central Administrative Tribunal.
That is not a legal point, Mr. Legal point means any provision of CCA rules has been violated by the disciplinary authority or appellate authority. You please point out.
My lord, the foundation upon which your lordship the punishment has been inflicted upon me, that is my lord inquiry report. And my lord, to my submission, nothing was proved against me by the IO. There, after inquiry report was supplied to me, I submitted my representation to it, my lord.
Nothing was proved means simply he says that charge is proved without giving reasons.
Exactly, this is my submission for
Where is
consideration.
the inquiring officer's report?
My lord, oblige your lordship. Inquiry report, your lordship, page number 36. This is dated March 10, 2010.
Page number?
It starts, my lord, page number 36. Inquiry report, March 10,
36.
2010, in the writ petition, your lordship. My lord, relevant page is page number 46. Conclusion drawn up by the IO. Page number 46, internal page 11 of the inquiry report, your lordship. No financial angle is there, your lordship, but I have been imposed financial punishment affecting my entire life, your lordship. Now I am pensioner, but I am getting, my lord, all the pensionary benefits have been affected, your lordship. I would get, my lord, I am getting lesser pension in every month, your lordship.
What was the post held by the petitioner?
Your lordship.
What was the post held by him?
My lord. In the charge memo itself, I was holding the post of, my lord, just my lord, accounts officer.
So is it not your duty to verify which are the rules in respect of the DEs? What is this expenditure? What is DES?
That was, my lord.
No, what is meant by DES and PE? Without abbreviation, you people address the argument. How to understand this, the DE and PE?
My lord, referring the inquiry report, your lordship.
Mr. Counsel, what is meant by DE
and
sorry.
PE? I am sorry, my lord.
That is the charge. Sanctioning of 3 DEs means what? 3 DEs and 1 PE.
Article number 1, my lord.
Sir, allegation is
detailed estimates.
Huh?
Detailed estimates.
Detailed estimate.
Detailed estimates.
And the PE means?
Branch estimates. Branch estimates.
Plan?
Branch estimates. My lord will be pleased to find page 20 of the brief. D. Detailed estimates.
We will not interfere, Mr. Counsel.
My lord,
These are not the legal issues.
my lord, one last submission for consideration. My lord, annexure 11, I am referring, my lord, page number 74. Two persons, my lord,
How many times you are
Again,
repeating
you
the
are
same
harping
thing?
on the same thing.
upon
Why are
Rameshwar,
you repeating the same thing like a parrot?
my lord.
You have already addressed on 2 occasions
This,
that there is a discrimination.
this order has been challenged before this honorable court, and this order got upheld, your lordship.
It is a different aspect. It is not in respect of common proceedings.
My lord, punishment is, my lord, not commensurate to this is excessive punishment, your lordship.
Sir, you being a responsible officer, accounts officer, you should have.
It was a, it can be taken, my lord, a mere negligence, but my lord, without any intention
Sir,
or motive.
you have ignored the relevant rules. That is what the inquiring authority says.
For my lord, mere
When there is a
my lord,
subordinate official proposed to
my lord,
whatever DEPA,
My
you did not look into the rule and
But-
simply sanctioned.
but my lord, it can
Is it not a negligence?
it can be said to be a mere negligence without any
No,
intention.
that can't be examined by
Intention motive is not
Yes,
involved, your
sir,
lordship.
respondent counsel, is there any financial loss caused?
My lord, he exceeded his financial power only to split.
No, it's all right, sir. Is there any financial
No,
loss?
That is not there.
Then
your
why
lordship.
can't you reduce the penalty?
Lord, only because of the fact that he was the chief person, Lord, he was the financial advisor of the TDA. He was holding the charge of the account officer. Also, he was working as a chief account officer. And every responsibility was his to ensure that the procedures prescribed in different circulars are followed before putting it before the authority. That he didn't do it. He simply forwarded the file and put his signature. That is. And therefore, after which, if my lord would be pleased to consider page 44 of the brief, where the charge number 3 has been discussed by the inquiring officer, and it has taken into consideration the entire things, and it has given a 3-page reasons why charge is being proved against him. Therefore, the submission that it's only a conclusion that charge is proved or not proved is not correct. My lord, from page 44, paragraph 3 on Lord, charge under Article 3, and it has taken 3 pages consideration before coming to a conclusion that this charge is so grave it is proved fully against him.
But my lord, financial angle is not there, my lord. So the punishment is too harsh, my lord, disproportionate to the alleged allegation.
Yes, sir. He has taken the instant petition. Petitioner has assailed the order of the tribunal dated 27th January 2017, passed in OA 870 of 2012, by which the tribunal has upheld the order of the disciplinary authority, order of disciplinary and appellate authority, orders dated 16/6/2012 and 15/7/2013 respectively. The petitioner, while working as a accounts officer and a financial head on in-charge basis, committed certain misdeeds for which he was subjected to disciplinary proceedings. In framing article of charges on 16/8/2008, he had submitted explanation on 13/8/2009 denying the allegation. In the result, inquiry was held. In the result, the disciplinary authority was not satisfied with the petitioner's explanation and proceeded to hold inquiry. The inquiring officer submitted a report holding that charge number 1 was not proved, charge number 2 was partly proved, and charge number 3 was proved. On receipt of inquiring officer's report, show cause notice was issued to the petitioner on 3/6/2010, for which a petitioner is stated to have submitted his reply. On receipt of petitioner's reply on the charge on the show cause notice, the disciplinary authority proceeded to impose the penalty of reduction by one stage in the time scale of pay for the period of 2 years with the cumulative effect. Feeling aggrieved and dissatisfied with the order of the disciplinary authority dated 16/6/2012, he preferred appeal. Appeal was rejected on 15/7/2013. Thus, petitioner filed OA number 870 of 2012, and it was rejected by the tribunal on 27/1/2017. Hence, the present petition. Next, learned counsel for the petitioner vehemently submitted that imposition of penalty submitted that two more officials were subjected to inquiry in respect of similar charges, and they have been punished with a minor penalty.
One exonerated, my lord.
Huh?
One exonerated,
One exonerated and another was
my lord.
punished with a minor penalty. Therefore, imposition of penalty on the petitioner, like a major penalty, is not commensurate with the proved charge. It is further submitted that it is a case of no evidence, for the reasons that the inquiring authority has not given finding in respect of partly proved and proved charge number 2 and 3 respectively. Therefore, the tribunal has committed error in not appreciating the aforesaid contentions. Full stop. Learned counsel for the petitioner has restricted grounds in respect of challenge to the order of the tribunal only to the above extent. Full stop. Per control and counsel for the respondent resisted the aforesaid contention and submitted that, having regard to the fact that the petitioner was an accounts officer and in charge financial head, he has simply proceeded to approve whatever the subordinate officials forwarded papers in respect of 3 DEs and 1 PE. Full stop. The inquiring officer has given finding in respect of partly proved and approved charge number article 2 and 3 respectively. Full stop. It is further submitted that question of discrimination among employees who are similarly charge sheeted cannot be appreciated for the reasons that it is not a case of common proceedings. Therefore, whatever the penalty imposed on another employee cannot be taken into consideration in the present case. Heard the learned counsels, therefore there is no infirmity in the order of the disciplinary, appellate authority and tribunal. Heard the learned counsels for their respective parties. Undisputed facts are that the petitioner was subjected to disciplinary proceedings in framing 3 articles of charges on 16/8/2008. Full stop. Charge number 1 was not proved, charge number 2 was partly proved, and charge number 3 was proved. Full stop. Thereafter, the disciplinary authority, after due compliance of show cause notice, proceeded to impose the penalty of reduction by one stage in the time scale of pay for the period of 2 years with cumulative effect, and it was subject matter of appeal in which disciplinary authority's order was confirmed to stop. Thereafter, the petitioner has invoked a remedy before the Central Administrative Tribunal, in which it was the order of the disciplinary and appellate authority were confirmed to stop. Next, learned counsel for the petitioner submitted twofold arguments, namely, the inquiring authority has not given finding with reference to material information, and the same has not been taken note of by the disciplinary and appellate authority. The aforesaid contention cannot be appreciated for the reasons that petitioner, being a accounts officer and the head of the finance section, he has merely accepted the recommendation submitted by his subordinates in respect of sanctioning 3 DEs, DE small s, and 1 PE. The aforesaid material information has been taken into consideration by the inquiring authority while giving finding that charge number 2 and 3 were proved partly and fully, partly and fully. The apex court time and again held that under Article 226 of the Constitution, writ courts should not reappreciate evidence. Therefore, the aforesaid contention is touching with the evidence, and the same cannot be reappreciated in a writ jurisdiction. Therefore, the aforesaid contention stands rejected. Next paragraph. The other contention is that the disciplinary authority has discriminated in imposing penalty. Like a petitioner was punished with the major penalty. On the other hand, other two persons, one person has been exonerated and another was punished with a minor penalty. The aforesaid contention cannot be appreciated for the simple reason that it is not a case of common proceedings among the petitioner and two others, so as to examine whether disciplinary authority has discriminated in imposition of penalty. To stop that apart, one has to draw inference each individual's role in respect of certain alleged allegations. To stop, in the present case, the petitioner was the holder of the post of accounts officer come head of the finance section, and there is a dereliction of duty as is evident from the record. Therefore, question of interference with the discrimination meted out by the disciplinary authority in imposition of penalty in respect of petitioner and two others cannot be appreciated. Accordingly, the present petition stand dismissed while confirming the order of the disciplinary, appellate and tribunals order dated so and so.
With your lordship, leave next case may kindly be adjourned for next Thursday, because my friend on the other side has requested me to supply the copy of a writ.
For what? Next case.
I want 1 week adjournment in next case, your lordship. Other side is not ready with the brief.